now we will deal with the amendments. There are three amendments 2015, 2019 and 2021. What changes had it made in the Arbitration Conciliation Act? We will quickly deal with them, and then we will go to your part 2. Okay, enforcement of foreign awards we will deal after that. I don't want to get inside foreign awards and then go to amendments, because amendments have mainly been given under your part 1 itself. Okay, so what does 2015 amendment do? 2015 amendment. Let's start with 2015 amendment. This made arbitration process fast and efficient. Just we will remember by one line what it did, and then we will go by features. So 2015 amendment, what was it doing? It was trying to make arbitration fast and efficient. Now let's see how it was trying to do that. So key changes, let's deal with the key changes that 2015 amendment made. Number 1, time limit for arbitral proceedings. Time limit for arbitral proceedings. Before the 2015 amendment, there was no time limit for arbitral proceedings. The 2015 amendment inserted section 29A. 2015 amendment, it inserted section 29A. What did this section say? It said that arbitration must be completed within 12 months. Arbitration must be completed within 12 months from the date the tribunal is constituted. From the date the tribunal is constituted. So the day arbitrators are appointed, now the tribunal is constituted. From that very date itself, the arbitration proceeding should be completed within 12 months. This is the restriction that section 29A does. Okay. Now 2015 amendment came up with this because some arbitration proceedings, they were getting very lengthy, and we had to make it more efficient because we don't want it to become a court proceeding itself. We want it to remain an ADR, right? So section 29A, 12 months, and also extendable by 6 months. These 12 months, they are extendable by 6 months with mutual consent of the parties. If the parties agree, 12 months में proceeding नहीं हुई complete, and if the parties agree, we will extend it by 6 months. So the whole limit is now 18 months. इससे ज़्यादा अगर चाहिए, इससे ज़्यादा extension चाहिए, further extension only by court on valid grounds. So there is a limit of 12 months. 6 months का extension चाहिए, that will be with mutual consent, and if after 6 months they want more extension, that it will be court's discretion on valid grounds. On valid grounds there will be court's discretion, and if the court allows or not, that will be completely dependent on the court. So there is time limit for arbitration proceeding. Your first very change that came with the 2015 amendment. Next is your fast track procedure. Time limit लगा दी. Now they also provided a provision for fast track procedure. Fast track procedure is your section number 29B. What does fast track procedure does? That award must be passed within 6 months. Fast track procedures में things happen very fast. So we will write in fast track arbitration what happens in this. Parties can choose a fast track procedure. Parties can choose a fast track procedure where dispute is decided solely on written pleadings. Dispute is decided solely on written pleadings. There are no oral hearings. There are no oral hearings unless specifically requested. There are no oral hearings unless specifically requested. And the award must be passed within 6 months. And the award must be passed within 6 months. So fast track procedure is basically a procedure where the whole arbitration is being conducted based on your written pleadings. There will be no oral hearings, but you can request one, and the award is supposed to be passed within 6 months. You've seen the documents, you've seen the arguments, all the pleadings are in front of the arbitrator. Arbitrator has been given the time to decide and pass the award in 6 months. This is your fast track procedure. So another key change with the 2015 amendment, this is why that's why we are saying that the 2015 amendment can be recognized by saying two words, that it was fast and efficient. Third is interim relief. Interim relief by arbitrators. Interim relief by arbitrators, this is section number 17. Earlier, only court can give interim relief under section 9. Now, after section 17, interim relief could also be given by the arbitral tribunal. Okay? So, just write this point down also. And whatever orders these arbitrators would pass, now they will be enforced like a court order. All the interim orders that arbitrators now pass, they will be enforced like a court order. Before 2015, only courts could give interim relief. Just write this down. Before 2015, only courts could give interim relief. After 2015, now arbitrators also can give interim relief, and the order would be enforced like a court order. There were changes also made under section number 5. Section number 5, that reinforce the judicial authority shall not intervene except where they are required. Except where they are permitted, they should not intervene. Section 5 was amended. And section 5 was amended, and again there was emphasis on courts, please don't intervene in arbitration. Okay. Fifth change is changes in challenges to award. Changes in challenges to award. Section number 34 was amended. Section number 34. So, public policy, the ground of public policy, it was narrowly interpreted. It was narrowly interpreted to set aside awards. It was narrowly interpreted to set aside awards. And there was also a strict time limit of 1 year. Also, right, they introduced a strict 1 year time limit. They also introduced a strict 1 year time limit for disposal of section 34 applications. They also imposed a 1 year time limit for disposal of section 34 applications. Okay, now you understand what changes came up with 2015. Now we move on to 2019 amendment. What changes came on with 2019 amendment? So we can say 2019 amendment completely institutionalized arbitration. The word that we will use for this is institutionalized arbitration. and confidentiality. So this was focused on this, institutionalizing arbitration and confidentiality. Key changes में we will start with creation of the Arbitration Council of India. Creation of Arbitration Council of India. This was the first key change by 2019. What is Arbitration Council of India? Just write 2 lines. Statutory body to promote arbitration. Statutory body to promote arbitration. Grade arbitral institutions. Grade arbitral institutions. And accredit arbitrators. And accredit arbitrators. So the whole aim of the 2019 amendment coming for the creation of Arbitration Council of India is that we are shifting from ad hoc arbitration to institutionalized arbitration. So this Arbitration Council, it will rate institution, it will accredit arbitrators, it will make policies and procedures, everything will be very institutionalized. It will be governed by the Arbitration Council of India. Okay. Second key feature, key change that came with 2019 amendment, stringent qualification for arbitrators. Stringent qualification for arbitrators. They made the 8th schedule more stringent. Now we are talking about 8th schedule. The qualification of who and who cannot be an arbitrator is in your 8th schedule, what qualification they should have, and 2019 amendment made very stringent qualifications for arbitrators. Okay, but this particular amendment, it has been removed by 2021 amendment. So we need to keep this in mind when we deal with 2021 amendment. Okay, this one, it came, this key change came and also removed by 2021. So when we write for 2021, we will note this down. Okay, third is confidentiality of proceedings. Confidentiality of proceedings, and this is in your section number 42A. All arbitration proceedings are to be kept confidential. In this point you can write, all arbitration proceedings are to be kept confidential except the final award, if required to be disclosed for enforcement. All arbitrations proceedings to be kept confidential except the final award if required to be disclosed for enforcement. Okay, this was another amendment that came under with insertion of section 42A. Reiterated that please keep all arbitration confidential, has to be kept completely private, otherwise proceedings can be initiated against whoever who violated section number 42A. Fourth is faster enforcement of foreign arbitral awards. Faster enforcement of foreign arbitral awards. This is your fourth key amendment that came with section number 47 to 49. Faster enforcement of foreign arbitration award. So there will be less judicial scrutiny. Whenever there is a foreign arbitral award, there is a lot of judicial scrutiny. So what these sections are saying, that there should be less judicial scrutiny, and Indian courts, they cannot refuse enforcement unless it meets the strict criteria in your Geneva Convention and your New York Convention. So they have restricted the Indian courts that they cannot stop the enforcement unless and until the criteria is not met of the conventions. Okay, so these are 4 key changes that came with your 2019 amendment. Very clear, very simple. 2015 में आया क्या, 2019 में क्या आया, and now we will go with 2021 amendment. Key changes in 2021 amendment. 2021 amendment का हम topic है preventing fraud and delays. This was to prevent fraud and delays. See, after you know what happened in 2021 amendment, you have the whole updated possession of the Arbitration and Conciliation Act. Okay? अभी क्या चल रहा है? We are dealing with contemporary legal development. What is the contemporary legal development regarding the Arbitration Act? You have the whole updated position after we finish this 2021 amendment. And excellent for your answers. You have to write the recent position only. There have been recently many changes in the Arbitration Act. So if you put something from the 1996 Act without including the amendments, then that's a very bad impression for your answers. You should know what the recent legal developments have been. So 2021 amendment, we will go with key changes. Number one key change is automatic stay on award removed. Automatic stay on award removed. This is your section number 36. Automatic stay on reward. So section 34 में, if we put an application to set aside the award, we are trying to challenge the award, there was automatic stay on the award. After 2021 amendment, this has been removed by insertion in section number 36, that there will be no automatic stay when an award is being challenged. Okay, so let's just write for this. Before 2021, if a party filed a challenge, under section 34, the arbitral award was automatically stayed. Before 2021, if a party filed a challenge, under section 34, the arbitral award was automatically stayed. After 2021, filing a challenge does not grant automatic stay. Filing a challenge does not grant automatic stay. Stay must be specifically granted by the court. Stay must be specifically granted by the court on justifiable grounds. So your second key amendment is protection against fraud and corruption. Section 36 clause 3, the amendment has been made in section 36 clause 3, protection against fraud and corruption. So if your arbitration agreement is prima facie induced by fraud or corruption, then the court will stay the enforcement of the award. That's what the amendment is saying here. So we'll just write court may stay enforcement of award. Court may stay enforcement of award if the underlying arbitration agreement or contract is prima facie induced by fraud or corruption. Prima facie induced by fraud or corruption. Clear? What are they saying in 36(3)? कि अगर arbitration agreement ही fraud or corruption से induced है, then we will stay the enforcement of the award. Second is omission of the 8th schedule. Third is your omission of the 8th schedule. What was the 8th schedule? 8th schedule talked about a qualification of arbitration. So the earlier requirement of having only certain professionals, omission of 8th schedule. This is conflicting with the second part of your 2019 amendment. The earlier requirement of having only certain professionals as arbitrators was seen as restrictive. The 2021 amendment deleted 8th schedule. The 2021 amendment deleted the 8th schedule, allowing parties to appoint foreign nationals as arbitrators. Foreign nationals as arbitrators. Okay. So we're done with all the amendments also, 2015, 2019 and 2021. I think the time is over now, so I have some part also to deal with arbitration.